This is a huge win.
Following a controversy over an ex parte meeting in chambers, the judge in Young Thug's RICO trial is off the case after one of his colleagues orders him to step aside.
I don't see how you rewind this case to June the 12th.
I look at what's next for the months-long RICO trial and talk with one of the lawyers caught up in the controversy. Plus, what does Young Thug's lawyer have to say about a new judge coming on board?
I definitely anticipate motions for mistrial, motions being filed for a mistrial.
Welcome to Crime Fix. I'm Angenette Levy. Judge Ural Glanville is no longer presiding over the RICO trial of Jeffery Williams, who's better known as rapper Young Thug. I'm going to go through the order for Glanville's recusal, but first, a quick recap on how we got to this point. It became clear that Glanville's days of overseeing the case might be numbered on June 10th when he held Williams's lawyer, Brian Steel, in contempt after Steel questioned why Glanville didn't tell him about an ex parte meeting in chambers with the state's star witness, Kenneth Little Woody Copeland, and prosecutors.
Mr. Steel, I am going to still hold you in summary criminal contempt.
The Fulton County DA's office maintained there was nothing improper about this meeting.
We certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of.
After Steel was held in contempt, he appealed and received a supersedeas bond so he wouldn't have to go to jail. That appeal is still pending. The trial continued, but you could tell things appeared to be pretty strained. Steel and attorney Doug Weinstein, who represents defendant Diamante Yak Gotti Kendrick, filed motions asking Glanville to recuse himself. Glanville eventually asked another judge to weigh in on whether or not he should be recused.
Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge.
Judge Rachel Krauss got the case and made her decision rather quickly. In a 10-page order, Judge Krauss cited case law to support her decision that Judge Glanville should be recused. Judges shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned. Judge Krauss continued, a judge has no interest in sitting on a particular case. At most, his interest lies in protecting his own reputation. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. One reason is that if he defends himself, he becomes an adversary of the movement for recusal. This adversarial posture may create an antipathy, which persists after the motion to recuse is denied. Judge Krauss wrote that there were 3 criteria for determining whether a judge should recuse himself or herself. In transferring the case to another judge for consideration, Judge Glanville necessarily determined that the 3rd criteria was satisfied, i.e., that recusal might be authorized if the facts alleged in the motion were assumed true. Once the motions to recuse were filed, Judge Glanville couldn't argue against them. He's essentially prohibited from doing so. Judge Krauss wrote, a judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming a basis for recusal. So what did Judge Krauss think about the ex parte meeting? She appeared to choose her words very carefully. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have, and perhaps should have, taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of the allegations, and otherwise explained his decisions and actions and argued why those actions were proper. So Judge Krauss basically said in that last part that Judge Glanville may have crossed the line when he tried to explain himself. In granting the motion to recuse, Krauss wrote, this court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied, but the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. Kayla Bumpus represented Kenneth Little Woody Copeland during that ex parte meeting in Judge Glanville's chambers. She was one of the people ordered to show cause as to why she shouldn't be held in contempt for disclosing the information. I spoke to her about Judge Krauss's decision.
I think it was the right thing to do. I think it's a step in the right direction for these guys to begin to get a fair trial.
Judge Krauss ruled that the show cause order related to Kayla Bumpus was moot. Glanville had mentioned that he saw Bumpus on surveillance video talking to defense attorneys. This is her response to that.
Judge Glanville, I can't remember if we talked after this, but I think we did. I mean, he put on the record that I'm on camera talking to Attorney Steele. So there's no question that me and Attorney Steele and other members of the defense team, Attorney Weinstein, there's no question that we had a conversation, and I never denied having a conversation with them. So yes, of course I talked to them, and I did tell them things that happened in that meeting. But if I had a chance to do it all over, I'd do it the same way.
But back to the RICO trial and the motion to recuse being granted. Judge Shakira Ingram has been randomly selected to preside over the trial.
I definitely anticipate motions for mistrial, motions being filed for a mistrial. I can't see anything other than that happening next.
How does a judge come in and take over in the middle of something like this that has gone on now for so long?
And for me, it's not necessarily just about the judge. It's more about the jury. I mean, how do they know what parts to trust, what parts not to trust? There's no way that they're going to not know that Judge Glanville was recused. They just can't show up one day and then there's a new judge. I mean, they have been sitting in this courtroom watching a lot of these motions and hearing a lot of this stuff. And, it's just the jury is like the big thing here. And we know it took 10 months to get that jury. So it's even if they retry it, I mean, then how long do we have to wait for another jury? I'm excited to see what motions are filed. I'm excited to see what happens next. I hope that if they do continue to move forward, that at least these guys are given bonds, the ones that qualify for bonds. Of course, we have rules that come with bonds, but I think that some of them definitely should have been given a bond from the beginning. And if they do choose to continue to move forward, I hope that Judge Ingram at least considers to give these guys a bond.
Attorney Doug Weinstein represents defendant Diamante Yak Gotti Kendrick and had filed a motion seeking Judge Glanville's recusal.
This is a huge win. This is a huge win because, look, again, I'm going to say what I keep saying, and I keep saying it because it's the truth. I do respect Chief Judge Glanville. He has a great reputation. He's done tremendous service to this community and through his military service. So I have a lot of respect for Judge Glanville. But at some point, I think any dispassionate observer of this trial on your network or anywhere else can see that, unfortunately, I think the judge has let bias creep in. And so I firmly believe that if this case were to proceed with an unbiased judge, we would get justice, we would get the outcome that our clients and Mr. Kendrick, and again, I'm just speaking for me, but that Mr. Kendrick deserves. So this is a huge win.
Unfortunately, the world is not always a safe place and accidents can happen. That's why I want to talk to you about Morgan & Morgan, a sponsor of Crime Fix. Morgan & Morgan has more than 1,000 attorneys that you may want in your corner because they are America's largest injury firm. And for good reason, they win a lot. They've secured several multi-million-dollar verdicts and settlements recently for victims who were in life-altering car crashes, all of which were considerably higher than the highest insurance offer. Starting a claim takes 8 clicks or less, and it can all be done from your smartphone. It's very easy. There are no upfront fees, and you only pay if you win. So if you are injured, you can easily start a claim in 8 clicks or less. Just log on to forthepeople.com/crimefix. So what does Brian Steele, the attorney for Jeffery Williams, Young Thug, have to say about this? I'll get to that in a moment. Lawrence Zimmerman represented Jeffery Williams' younger brother, Quantavious Greer, at the beginning of this case. So, Lawrence, thanks so much for joining me. Your thoughts on Judge Krauss telling Judge Glanville that he has to recuse himself?
Thank God. It's good to see that justice has been done. This has been a long time coming. This has been a slog. This has been one of the most unfair, unjust, what other words that look at the thesaurus, I can keep going all day to anything that is synonymous with unfairness and injustice, unjustice. Been a horrible trial. Forget how the lawyers have been treated. These jurors have been treated poorly. I mean, stuck in a trial. It's already gone on for about a year and a half. Breaks nonstop. They don't know what's happening. It's been just insane to watch the whole thing.
I haven't talked to any current or retired judge who didn't think, when I told them that jury selection took 10 months, that didn't think it was absurd. They couldn't believe it, that you would take 10 months to select a jury and then have the trial drag out in the way that it has. So what do you see coming next? Because a new judge is going to have to come in after all of this, Judge Ingram, look at the transcripts, I'm assuming, look at everything that's unfolded, and look at little Woody's testimony and everything that happened with that, and then decide, do we just pick it back up? Or I mean, what do you see happening? Because I feel like this is such a mess. Just looking at it from the outside in, I don't see how you just keep going with everything that has happened.
Well, first, there's still a pending motion that Brian Steel filed to recuse the Fulton County District Attorney's Office. So that hasn't even been dealt with yet. So first, they're going to have to deal with that, number one. He's alleging it was completely unprofessional and unlawful, quote, unlawfully ethically, to be in that meeting ex parte without telling anybody, with the judge, with Woody, Kenneth Copeland. So you have to deal with that. But to your larger question, this is actually uncharted territory. I'm not sure there's many cases we could find around the country where a judge has been removed, where they didn't drop dead, didn't get really sick in the middle of a trial, especially a trial that's going on this long. I've asked a lot of other lawyers. Nobody really knows of one. And most were sort of the opinion, they didn't think that the judge would be removed, because how do you remove a judge from the middle of a trial, especially like one this large? And to your point, how is Judge Ingram going to catch up on the case? Does she need to read from day one the openings, or can she just basically say, I have a pretty good idea and understanding of what the case is about, just jump right in? I don't know. I mean, if she has to read the transcripts, it's going to take another 6 months till this case starts back up. But then what? I could say this. I absolutely am certain that the defense is going to renew and file more bond motions to get their clients out on bond. Because Judge Glanville denied every single person a bond in this case. And honestly, there was no basis for that. There were people involved in this case that were on the periphery, that have never been in trouble before, that didn't get bond. She denied bond to everybody. So, I mean, this is uncharted territory.
Brian Steel released a statement last night. His wife, Colette Steel, who's also an attorney who practices with him, sent it over. Jeffery Williams is innocent of the charges brought in this indictment, and to clear his name, he sought a speedy trial, one in which he would receive the constitutional guarantees of a fair trial with an impartial judge presiding and ethical prosecutors following the law. Sadly, Judge Glanville and the prosecutors have run afoul of their duties under the law. Mr. Williams is grateful that the reviewing court agreed with him and entered the order recusing and disqualifying Judge Glanville from presiding over Mr. Williams's case. We look forward to proceeding with a trial judge who will fairly and faithfully follow the law. So he makes it sound like maybe the trial should keep going. But wouldn't you anticipate maybe he would want a mistrial after all of this?
Well, sure. If he gets a mistrial, that'd be great, because there'd be double jeopardy issues. And Brian would argue that the district attorney goaded him into moving for a mistrial, to then later bar the trial again. Brian wants a fair trial. I mean, in full disclosure, he's one of my very close friends. I rented space from him and his wife for 15 years. So, and so I'm a little biased, but I will tell you, and I know, there's no lawyer that works harder than him, that fights harder. I mean, nobody. He is one of the smartest people. He's the most successful appellate lawyer in criminal cases in the state of Georgia. And he's a fantastic person. And it breaks my heart to see how this judge has run roughshod over him, and just, I mean, even one time called him unprepared. Calling Brian Steel unprepared is like saying the sun isn't hot. So Judge Glanville really, really messed this case up, and he really showed his true colors. And I'm glad Brian's still standing tall, and he's going to fight for Jeffery Williams. He's not going to take a plea. He wants his case to come to a logical conclusion with a not guilty. But sure, a mistrial, as long as they retry it again, maybe that's what they'd want. But I think they want to just get through this case. I don't watch this case every day. I catch the summaries. My paralegal is pretty involved in this case as well, but she tells me what's going on. I've yet to see where anybody could tie Jeffery Williams to any crimes. It's been pretty much to do about nothing so far. Whatever the salaciousness of the events are, the people involved, but I can't see a jury of 12 all agreeing to convict Jeffery Williams if they even remember the evidence in another year.
So what do you see happening with the motion to recuse the Fulton County DA's office?
That's going to be a tough call because, I mean, certainly if they recuse the Fulton DA's office, the case is definitely over. Judge Krauss, I read her order right when it came out yesterday. It's a decent order. I felt she had courage. I think she was sort of towing the line not to completely criticize the chief judge of Fulton County. I don't think she wanted to embarrass him. I mean, she even dropped some language in there about ex partes could have been done in a better way in open court. I'm not so sure an ex parte, the way that it all occurred, could have been done at all, unless the defense was present or notified. Certainly, the ex parte couldn't have been done with a district attorney's office in a closed hearing without anybody else present. That's not allowed. And remember, Kenneth Copeland was under oath when Judge Glanville spoke with him. So these are all issues that Judge Krauss is going to have to ferret out and determine whether the DA's office should be allowed to stay on the case because they had very unclean hands at this point.
Well, Judge Krauss didn't completely disagree with how the fact that an ex parte meeting could have occurred. She said that, but you're right. I feel like she was trying to be very careful not to criticize Judge Glanville. What do you know about Judge Shakira Ingram?
I've only had one case with her recently. I found her to be very nice, professional. I didn't have any rulings or I didn't have any litigation. The case resolved very favorably for us. But listen, I just want a judge who's kind and professional to start with. Certainly one that understands the law and makes good rulings, but you just want a judge to have a good temperament. You were there doing the people's work. You're not a king. You're elected by the people, get paid by the government, and people want to have assurances that the court system, the criminal legal system, is working in the way it was designed, which we all know it doesn't work the way it should. But you certainly want judges up there calling balls and strikes. You don't want them favoring the Yankees over the Red Sox, right? You want them to be the umpires who will be ethical and neutral when calling the game. And that's not what happened with Judge Glanville. If you watch the case, every single time Brian would ask a question, the prosecutor, Adrian Love, would just object, just to object all the time, even objections I never even heard of. And Judge Glanville would sustain them. I mean, and let's stop me if I'm ranting, but if you look at my client, Jimmy Winfrey, who I represented in 2015, he took a plea against my advice, by the way. I didn't participate in the plea. It's a whole other story. But he pled an Alford plea. He didn't admit to anything. That case then got overturned on appeal by the Supreme Court because the judge threatened him. That's why I refused to participate. Got overturned. The state of Georgia in this Young Thug et al. Case tried to use that guilty plea as an admission about YSL in Jeffery Williams' case, and Brian objected. The Supreme Court vacated that conviction, said he was coerced. That can't come in, but Judge Glanville still let it in. I'm actually on the witness list in this case because of that. So it's crazy. If something gets thrown out, you can't admit that into court. So my point is the bias is ridiculous. That's not how court should work. That's how judges should be. And let me just say one more thing. I can't tell you how many judges around the state of Georgia stop me all the time. They just ask me, what is going on there in Fulton County? I can't believe what this judge is doing. We've never heard of this before. I have judges texting me.
And just so our viewers and listeners know, an Alford plea is a plea agreement in which a defendant can say, yes, there's enough evidence where I might be found guilty. I will plead guilty or plead no contest, really, and just acknowledge there is enough evidence for a conviction, but I maintain that I didn't do anything wrong. Essentially, that's
right. That's not. I conflated things. After his first plea got vacated when I represented him, and then I referred it to another lawyer to the appeal. They won that appeal. He pled guilty again, but he did it out for plea the second time. So neither of those come in at all. And then Judge Glanville let both those in, and the law is pretty clear. When you have a lawyer like Brian Steele telling you here's the law, and he's the most winningest, that's a word, appellate lawyer in Georgia, you should probably listen to him. He's usually right.
Well, we will keep an eye on what happens next. Lawrence Zimmerman, thank you so much for joining us.
Thank you for having me. I really appreciate you.
And that's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.